Hello, everyone. Welcome. We are here with our legal team. We've got Kelsey Marsh, Emily Teal. They are our associates, and Katie Rakowski is our paralegal. And we're going to be doing today a topic about what to do with the house. This is a common question we get from clients all the time. They want to know what we do with the house. Do we keep it? Do we sell it? And it's a big decision and lots of nuanced questions that come with that. And so we thought, what better way to address this than talking with our local experts here and picking their brains about what they tell clients and what clients need to know. And we will also address any questions that may pop up in the chat. So if those come up, we can address those as well. Okay, so let's kick off with keeping selling. So what do we do? So clients will often ask, what do we do if my husband wants to keep the house and I want to sell it? If I'm the client and I ask my attorney, I want to sell the house, I'm cool with selling it, but he's the one that wants to hold on to it. How do I get my money? Like, how do we address this? What kind of advice do you guys normally give? Emily, if you want to start us off.
Yeah, sure. So one of the first things that we're going to need to do is determine the value of the property before we decide what happens with it, how we're dividing it, and how it's divided. We have to know what we're working with. So that's really step one in any process. But there's so many levels related to that because what do you use to determine the value? So you have to look at what is the source of the value for the property. We have formal sources like getting an appraisal done. Obviously, that's going to incur some fees, but if you're selling the house, that's something that's probably going to be part of the process anyway. You also have informal sources that are like your Zillow Zestimate or the redfinrealtor.com. And in between the formality of those, you have the Collin or the county appraisal district values that you can look at too. So those are all things that we want to look at. Obviously, we want to get the most realistic number for the property. And then once we've got a value that everybody decides on, we also need to look at, are there repairs that need to be done and that kind of thing. But that's really step one is what is this asset actually worth?
So, in talking about the values, Kelsey, like what do you do, say, if the husband really gets stuck? Like he wants to, I think normally, if you're the person keeping the house, you probably want to keep the price low. And if you're the person who wants to be bought out, you want to get the price as high, the value as high as possible so you can max out the equity that you pull out. What happens if, say, the husband who's wanting to keep the house is saying, I'm going with the CAD value because they know it's a little bit lower, and what do you tell the client? How are we going to address that if they insist on the CAD value?
Sure. So I usually would get values from a couple different sources, and then we would discuss those different values. If the husband is still adamant, no, this is the truest value. The other thing we can do also is we can pull in an expert to get some comps around the area, see what similar properties have sold for recently. And that tends to be a little bit more accurate as well because it's more recent. If we're still in a disagreement and we're just not able to come up with an agreed value, then we may need to go to court and have the court rule on what is the most accurate value.
Okay, cool. Okay, so once we've got the value identified, what is the next step here in the process? What is the next consideration, Emily?
If we're going to be selling the house, it's a lot of logistics. Who's going to be living in the house until we sell it? Who's going to be listing the house? What's the listing price and strategy? So you guys the spouses may agree that we need to sell the house. They may even agree on the value, but they might not agree on, do we list it low and get a bunch of offers, or do we list it high and build in that room for negotiation? So those are the immediate next steps is, great, if we're going to sell that, how and when are we doing that? Who's paying the bills in the meantime, and who's handling all of the repairs and that kind of thing. So those are some considerations that need to be taken into account, especially if it's going to be sold after your divorce is final. We need to have all of those terms listed out in your divorce decree ahead of time so that it's enforceable. It's not something where when we got your biggest asset that we're operating on a handshake and hoping things go okay, we really need to have those terms laid out in advance.
Yeah, I don't think a lot of clients necessarily realize that they really do the handshake thing. They'll come to us and say, I don't think they think about some of those details sometimes. It's just, sure, he'll live in the house while it lists and I'll move out and go start my life. But they don't think about those little nuances like, how are the bills going to get paid? And then if they're living there while the bills are being paid, say the mortgage is being paid, there's also a difference in how those bills are going to be treated, right? Because they may feel like if I'm living here, I want the benefit of the mortgage being paid off. And I think there's a difference between pre-divorce and post-divorce. What do you tell clients about how the bills are going to be paid and when they start saying, I want it reimbursed from the sale of the house?
Yeah, I think it really is going to depend on how we're splitting the house, right? So if it's I have a flat buyout number. Let's say the husband is keeping the house, and regardless of, we know he needs to sell it to get my name off the mortgage and to buy me out. But regardless of how that happens, when that happens, the repairs that need to be done, I've got a flat buyout number. And so I know I'm getting $150,000. That's great. You have less to worry about in that scenario, but it may not be realistic because of the rest of your estate. We may not be able to come up with a flat number if there's other things that are contingent. So if it's a situation like many cases or most cases probably where you're going to be splitting the proceeds in some kind of percentage value, you want to be thinking about those things. And so one thing you mentioned was who's paying the mortgage. For example, if you have the husband keeping the house after a divorce is final and he's paying down the mortgage from his funds after everything has been separated, then basically he's increasing the principal on that loan during that pendency of the sale. And if he's going to be awarded the proceeds, that's maybe fine. But if you're going to be splitting the net proceeds, that's something that you need to calculate. How much was the principal paid down? And was that really from shared funds that should be split 50-50? Or was that solely from funds that I was awarded or the spouse was awarded in the divorce? It may not be fair to split that 50-50 or however else is
So
decided.
what you're talking about is he continues to stay there for a period of time after the divorce, but eventually the house sells and they've
Mhm.
agreed on that. I guess what happens though if they don't agree to sell the house and husband wants to continue living there? Kelsey, can you address maybe some of the issues that the clients need to consider if they don't plan to sell the house and husband just wants to live there and just keep the house?
I think the first thing is going to be, is he going to be able to at some point just put it in his name solely? Is he going to be able to refinance the property? Because if he's not going to be able to do that, then I think there needs to be more serious conversation about selling. Otherwise, you'll get into a situation where he may be living there for the next 6 months just to figure out he can't actually keep the house. But if he is going to refinance it, then I still think you need to figure out how much of the principal was paid down and with what funds while he was staying there. And then what was the other spouse's arrangement? Where were they staying? How were those bills being paid?
Yeah, I think there's a difference there between pre-settlement or pre-divorce, where you're using community funds to maintain a community asset, versus once everything is agreed and settled and separated, then I think reimbursement claims may pop up there if a person continues to improve that property at that point because you're using separate funds. So I think that's also a distinction sometimes that we have to make with clients is there's a point at which it doesn't really matter because it's all community, and then at some point it becomes separate, and at the separate point then it's more fair to look at whether or not there somebody should be reimbursed for bills and for paying down things. Yeah. And the refinancing is really interesting. So let's flip the script. So say that our client wants to keep the house. And so we represent women, and oftentimes they are not the moneyed spouse. So what happens in a situation, say we get a lot of clients who are like, that's where my kids grew up. I want to keep the house because of my kids. There's a lot of memories there. It's close to the school. And so I want them to remain in that neighborhood. What kind of conversation do you have with them when they're insistent on keeping the house? I don't know,
So it's
whoever
really,
wants to jump in.
yeah, I'll go first. It's really a two-part conversation, right? It's can it happen? And then if it can happen, how do we make that happen? And so sometimes we know up front, like we're trying to be really proactive with our clients and have them work with their mortgage lender to determine that step one as early as possible in the case. Can they actually qualify? For whatever reason, there's some cases where we don't know that going into mediation. And so in that case, we would build in a contingency. When we go to step two is how do we make that happen? We would want to negotiate maybe a longer time, maybe instead of 60, 90 days to refinance, maybe we can negotiate 6 months to a year. And that gives more time just on a practical level to be able to have those conversations. And then in terms of logistics, it's what are you using to qualify? You need income and assets. And if you're going to be keeping the house, but you don't have cash on hand, is there another asset that we can negotiate in your divorce settlement that will get you what you need in order to be able to qualify for that loan? And so that could look like maybe additional front instead of taking 50% of every account, maybe you're taking more of a cash and liquid asset so that you have that on hand for the down payment, and prioritizing liquid funds over longer term assets like retirement. There's also, in terms of the income component, you can use things like child support and spousal support towards your income to qualify for a mortgage. And that's where we hand it over to our mortgage experts. And we know that's a possibility in some cases, but not all cases. And so that's where we would have our clients work with a lending expert as soon as possible to see how long do they need to be receiving those payments in order for them to actually qualify as part of your income equation.
Yeah, I don't think some of our clients realize that it's not just income for a little bit. It's actually has to be very well thought out. Oftentimes it has to be 6 months before the divorce and then 3 years after the divorce that they have to be receiving some sort of spousal support or child support. So if you've got a situation where you've got like a 16-year-old kid, you're not going to hit those child support for 3 years because they're going to age out in 2 years. Then we have to figure out, okay, that's part of the conversation, right? Is we can't get it that way. Are there other ways that we can do it? Maybe we can negotiate that alimony for that extra year or something. But if the husband really doesn't want to pay alimony, it may be just something that the client has to wrap their head around and start thinking about a plan B.
I think that's an important point you bring up too, Alex, is that you have to think about the emotional side of it too, right? So when they're saying, oh, there were a lot of memories there with the kids, sometimes we have to bring it back and say, yeah, there were a lot of great memories, but were there also some not so great memories? So would it actually be better for everyone to move forward and to move on to a fresh start in a new place? And then also when you're thinking about the financial aspect, how that will affect the emotional. If you are just scraping by every month to keep the house, is that really going to be what's best for you and the kids moving forward?
Yeah, yeah, definitely. I think those are good points as well. Yeah, good points. All right, so let's see here. What other questions do we have? Sometimes we get asked, so say the parties come in, they want to sell it, but they're like eager to sell it. We're not ready to file for the divorce yet. We want to sell it before we get divorced or before we even file. We are confident that we're going to be able to reach agreements, but it's May, it's hot buying season. We got to get that house listed. What kind of conversation are you having with clients who approach us? Maybe they're not ready quite for the divorce, but they are ready to get that house on the market. Emily, you want to start? Or Kelsey,
Sure.
whoever wants to jump in.
Yeah. So listing the house while the case is pending is usually completely fine. The question comes with what if you sell the house while you're still not divorced? So when you sell a house and you're not divorced, all of those proceeds are still community funds. And what do you do with them? And so I keep referencing 50-50 because that's the standard in a lot of divorce cases. Obviously, there's some cases where you're going to have a more substantial split in favor of the wife or the other party, but I always go back to 50-50 just as the basic example. So with that said, if you take the proceeds and you split them 50-50 right when the house sells, you run into some problems because what if I have my 50%, the other party has their 50%, and then by the time the case actually settles, their 50% has been spent on Starbucks and new shoes and whatever else, and then the only portion that's remaining is the portion that I hold. That's still community property and can still be divided. And so that's really the risk is if you agree to divide things while the case is pending, it's all still community funds and it's all still subject to division. So that's why in many cases we like to hold the funds in a trust account, whether that's the registry of the court, an attorney's trust account, or just another kind of trust account where the funds can't be touched. So that's the safest way for clients to protect their money while a case is pending, is just hold it until we know what that final split is going to be. And then we can divide it in a fair way from there without having those risks.
Yeah. Yeah. And then what if a client comes to you and says that they want to pay off debts from the mortgage proceeds or from the equity proceeds? Kelsey, do you want to talk about that a little bit?
Yeah. So going off what Emily was saying, you're in the same starting point of that. I think sometimes clients get confused of all the debts also community. And so it's all 50-50. But again, we don't know what debts we're looking at. And so we don't know how they'll be split. We really have to get everything in front of us to see what are the debts, what is the value of all of the debts, what are the values of all of the assets. And it's not, that's the issue, is that it's not so simple of, oh, just split everything down the middle. Sometimes it is, and sometimes it's not. And so we really have to be able to have a full picture to make sure that everything is divided appropriately. And so that's the other thing you run into, is if you say, okay, you go pay these debts in your name and I'll go pay these debts in my name, and you're trusting that someone's going to go and do that, it doesn't always happen. And so then what if those funds have been given to pay off a debt and then that ultimately doesn't happen? You're in the same position that Emily was talking about, where that debt still exists and that debt is still subject to division.
Yeah. Yeah. A lot of things there. And I think we also run into the issue of clients trusting that their husbands are going to do right and do as they say, and then sometimes finding out that they did not do as they promised. Definitely want to protect them from that. Yeah.
And so many of the issues that we're talking about today, the remedy is information. We need all the account details. We need all the statements. We just need to see, like Kelsey said, the full picture before we as your attorneys can advise you on what a good decision would be. And so there's a lot of rabbit holes to go down, but it's all fixable as long as we have the information. We just really need that full picture before we can say, okay, now that I see it clearly, this is what we need to do.
Yeah. I think a lot of our clients too like to, they don't want the conflict. They want to get this done. And so they're really eager to get this done. But I think part of our role is to just slow them down, make sure that they're making an informed decision so that we're helping protect their future as well. And so we know that they're in a situation right now that maybe they're not thinking as logically, they're thinking more emotionally. And so they want to get it done quick, and they just need to slow down and make sure that they are doing it informed. And getting the information can sometimes take some time and gets frustrating, but it's definitely an important part of protecting their future. Okay, let's see here. What else we've got for these questions. Have you guys ever, okay, we can skip that one. What about inheritance? So inheritance and separate property. So a lot of times we'll have clients who maybe the in-laws will give them a gift, or parents will give them a gift as part of the down payment. And is that a gift to both of them? Is that a gift for one person? Or maybe they'll use inheritance. Maybe a parent's died and now one party has used their inheritance as part of the payment towards the house. How do we deal with that?
Yeah, so you really have to determine the source of funds first. So everything starts out in the community property bucket. If you want to show that it's your separate property, you have to prove that through clear and convincing evidence. And so separate property, as you mentioned, is things like inheritance or gifts. Now, when it comes to the house, if you're using separate property for the down payment of the house, your separate estate owns a portion of that house in proportion with the down payment. So let's say it's a $200,000 house and you use 50,000, or I don't know. I'm not great with the numbers.
50,000 would be a fourth, would be 25%.
Yeah. So let's say for the down payment, 25% of the down payment comes from separate property funds. That would mean that the separate estate is going to own 25% of the house and the equity in the house. And then the community estate owns the rest. And you still own a portion of the community estate as well. So you might have this whole portion that's your separate property, as well as a portion that's owned by the community. And so we really have to be diligent in tracking where those funds came from, and then how they were traced and how the property has increased in value over time. And then, as you said, Alex, like sometimes it's clear it's inheritance that was used and it came straight from an estate and was used directly for this down payment. It was never commingled with anything, and it's a little bit more straightforward. Sometimes you have a check that's to one of the spouses, and then you have to go, okay, was that check from grandma a gift to wife, or was it really a gift to husband and wife to buy their house together? And even if it is separate property funds, you still have to look at what was the intention behind that. And those are things that if we're at the negotiation and the mediation stage, we can be a little bit more flexible on our arguments versus if we go to court, it's, can you prove this? Yes or no? And it's a little bit more cut and dry. That's why mediation is such a powerful tool, because we have, when it benefits us, we have that flexibility to make those arguments.
Yeah, good. Yeah. Anything you want to add, Kelsey?
I was just going to say, so like that can become very expensive too, right? You might need specific tracing experts. And so that's something you always want to consider too, is what you might gain out of it worth what it will cost in order to prove that? So just something to consider.
Yeah, no, it's good. Okay. I don't know. That's the questions that I had that generally come up for clients. I don't know if you guys have anything else you want to add to it, or Katie, in your conversations with clients, if there's any other questions that pop up that I didn't think of.
I did want to touch on one thing that we touched about earlier is the refinancing. We may say one spouse is keeping the house and gets to refinance. And what happens if they can't, though? What happens if they don't qualify or they lose their job? And so that's something that is easy to address, but we have to put it in the divorce decree and say something along the lines of, yes, we hope that they refinance and we hope that they buy you out for this amount of money. But if that doesn't happen, then we still need the contingency of the sale. So it's not an either or. Usually it's this is the goal. If that can't happen, we've already taken care of that and put those terms in the decree. And I think we touched on that earlier, but just to make it clear, like we would, even if the goal is to refinance, we're still going to protect clients and make sure that there's a contingency if that falls through for some reason.
Yeah. Yeah, it's definitely happened. I've gotten cases from other clients come to us a year or two later. Husband was supposed to have refinanced, and the attorney, whoever it was, didn't put in a sale provision, a contingency provision, and now we're stuck. They didn't refinance, but maybe we can't do anything either. And the risk there is that they continue to have that mortgage in their name, and there's really not much they can do. It's affecting their credit. It's affecting their ability to buy a house. It's affecting the interest rates they're getting. So it's really important that we figure out a way when we can during the process to put in that contingency to make sure that debt does get removed from their name.
Yeah. You don't want to be holding the bag a year later and have to go back to court, take on all these new filing fees and start over on that piece of it.
And sometimes the court's hands may be tied even. There's nothing that they can do, and you just have to hope that your ex does what they're supposed to do. Yeah. But okay. All right. Anybody?
Can I jump in just real quick? Just to reiterate what the ladies are saying, from my perspective, when we ask you to get started on part of the process on the front end, if you are wanting to try to keep the house or refinance or whatever, some banks will assume a mortgage. I don't know if I didn't specifically hear you guys talk about assumption, but if you call early enough on your mortgage, call your mortgage company and say, do you do assumptions? And maybe someone doesn't have to refinance and you can just get your name removed. But that would be things that would need to be known pretty early on. And there's probably a 30, 60, 90-day process that is involved in all those things. So if we send you a referral or say to call or start getting a jump on things, those are advantageous to you to do early on, because then we, like you guys said, having information is the remedy to all of this. And so doing it early is ideal. And then we have that information to work with, and it just helps in the long run.
Yeah, assumptions, that's a great, I think a lot of people too assume that they can get an assumption. And it used to be actually pre-COVID, it was really hard to get an assumption. And lately, last couple of years, I've seen more people getting assumptions, which is great. And for those who don't know what an assumption is, you can assume the mortgage. So instead of refinancing, some banks will let you just assume the mortgage without having to go through and get new interest rates and new applications. And there's a lot of fees that come with refinancing. But with an assumption, it's a really low cost, no cost way, and you just take over. Now, not every bank will do that. And it also doesn't make them money. And so part of the problem is that some banks will be very prompt. Some of the creditors are very prompt and they'll do the assumption very quickly. Others will take their time. And so it goes back to building in that contingency plan. You give your soon to be spouse or soon to be ex a deadline to get it assumed. But if they can't get it assumed within 6 months or whatever, then we need to figure out what that next step is to get your name off of that. Maybe it's a refi, maybe it's sale of the house. That's important consideration as well. That I think people think it'll happen quickly, but it really doesn't. Some banks, they don't make money out of this. There's no motivation for them to do it. So they can take a long time to get it done. All right. Thank you, ladies. I really appreciated you coming and joining on the call and sharing your knowledge with everyone. And I hope everyone who's watching enjoyed it as well and got some information out of it. And we will be sending an email out for our next month's topic, which we haven't quite decided yet, but it'll be based on things that we're hearing from our clients. And we encourage all of you to attend so that you can ask your questions live and hopefully get an opportunity to have us answer it for you here. So thank you.
Thanks, Alex.
Thanks, guys.